The other provision that the FCC cited to in its notice of proposed rulemaking is Section 201B of the Communications Act. That section is the grants the FCC general rulemaking authority under Title I of the statute. And I think this is no doubt broad rulemaking authority expressed in very broad terms. But as a basis for ancillary jurisdiction, I think there are two problems with this provision. The first is that the Supreme Court has made very clear that agencies cannot fall back on their general rulemaking provisions to expand their powers into new areas. It's sort of an anti-bootstrapping principle. If agencies could do that, then simply by virtue of Congress passing a broad rulemaking provision, which it typically does for agencies, agencies could sort of exercise authority over anything they like and sort of continuously expand their authority. The Supreme Court in a case called Dimension Financial rejected that approach and said, no, you've got to do better in terms of identifying a source of statutory authority that the general rulemaking provision itself won't do. The second problem with Section 201B is that the FCC's authority is that it concerns the FCC's authority over common carriers, its general rulemaking authority over common carriers. Why is that a problem for the FCC? It's a problem because the FCC, as I mentioned before, has gone out of its way to define internet service providers as information service providers and not telecommunications carriers that are subject to common carrier regulation. So again, given that FCC interpretation, it's a very odd thing for the agency to be relying on the rulemaking authority in Section 201B to regulate internet service providers, which are, according to the FCC today, information service providers. There's a couple more general problems, I think, with the FCC's exercise of ancillary jurisdiction here. The first is that the general notion of passing internet traffic rules is inconsistent with other parts of the statute. The statute explicitly says that the FCC's Organic Act, 1996 Act, explicitly says that the FCC cannot treat entities that are not common carriers like common carriers. And again, this gets back to the FCC's prior interpretation that internet service providers are not to be treated like common carriers. So under the terms of the statute, the FCC shouldn't be treating them like common carriers. And that inconsistency with other provisions of the statute is something that the Supreme Court and the D.C. Circuit have pointed to in other cases in which they found the lack of ancillary jurisdiction, a lack of ancillary jurisdiction. And then more generally, I think the problem with the FCC's exercise of ancillary jurisdiction here, or attempted exercise of ancillary jurisdiction, is that it would in effect amount to a boundless conception of jurisdiction, the very thing that the FCC cannot do under our separations of power, because if these statutory provisions that I've talked about are sufficient to support the exercise of ancillary jurisdiction, then surely almost any statutory provision would be sufficient. And the Supreme Court, and in particular the D.C. Circuit, has said that ancillary jurisdiction does not exist to give an agency unbounded authority. So what does the FCC do? What can it do if it doesn't have ancillary jurisdiction over these provisions? The obvious thing that it can do is it can go back to the source of the authority and ask for authority. And that's, of course, Congress. The FCC could go back to Congress and say, pass a law giving us explicit authority over the regulation of the internet. The FCC has not done that, at least recently, as far as I'm aware. One of the reasons why it may not see that as an attractive option is that, as I mentioned, Congress has considered bills explicitly giving the FCC authority over the internet and has not enacted those bills. So the FCC may not see that as a viable legislative option. It does seem to me, though, that it would be appropriate for the FCC to go to Congress. This isn't some minor regulatory issue that we're talking about. The FCC itself has described the internet as something that has, quote, transformed our nation's economy, culture, and democracy. It seems that something that important, and we all know how important the internet is in all of our lives today, is precisely the kind of thing that ought to be the subject of debate from our nation's elected representatives. So that option certainly remains to the FCC. Another option that the FCC is reportedly considering is to go back on its interpretation of the 1996 Act and conclusion that internet service providers ought to be treated as information service providers, overturn that interpretation, and pursue ancillary jurisdiction or exercise of jurisdiction under Title II of the Act, treating internet service providers as common carriers. It seems to me that there are two issues that the FCC would have to work through there. The first is it would have to formally flip its interpretation, an interpretation which it reached after much consideration and thought all the way to the Supreme Court. And then it would have to provide a reasoned explanation for that interpretation. As the Supreme Court made clear just last term in another FCC case, FCC versus Fox, there's nothing that prevents an administrative agency from changing its position over time or even from one administration to the next. But when the agency does that, it still has to provide a reasoned explanation. So the FCC would have to provide that explanation, and then in defending it, it would have to deal with all the statements it had made earlier about why the exact opposite position was reasoned and made sense. And then the FCC would have to issue a new notice of proposed rulemaking because it hasn't identified Title II as a source of authority for regulating broadband internet access yet, and so it would have to identify that, and then we would be basically back to where we were in October 2009 when the FCC issued its notice of proposed rulemaking that we're discussing today. And at that point, we'd have to think about whether or not it would make sense to examine this issue and write another paper. So I think I will stop there. Thank you very much.